Turn Dwayne Hops here. I got two tips that will save you thousands of dollars in attorney's fees when it comes to your estate. And so it's better to be proactive than reactive when it comes to estate planning. And these tips do not cost that much money versus as it will after you transition or pass away, or after your loved one transitions or pass away. And they affect things that cost hundreds of thousands of dollars. You see, if you and I'm not even talking about a will, I'm just talking about doing certain things to make sure you're protecting your assets and the people that's going to get those assets, to protect your house and making sure it goes where you want to. And it really comes down to your estate, and so you need to consult with your lawyer based on what I'm talking about. So this is not legal advice. This is just me putting nuggets in your ear so you can talk to your lawyer about these things. And these two things are going to save you lots of money. I might throw a third one there too. So let's get straight to one that's going to save you a lot of money. If you have a bank account, and it sounds common sense, but a lot of people do not do it. And this is what I do using the will. Simply start thinking about the person you want your money to go to if you was pass away. You may not do it on all your accounts, but you might want to do it in your savings account. And you might don't even tell this person. You might do it. I've heard some people doing it grandkids. Simply add the person you want the bank account to go to as a co-owner account. It'll be a joint account. They just won't know about it. Then some banks have a beneficiary card. You can go in there and sign for that account. So when you pass away, or your mom passed away, have your name on the account or sign on that beneficiary card, you won't have to try to jump through hoops to get a lawyer, to get an affidavit, or jump through hoops and go to court to get that money out the account. You simply only have to talk to the bank, and they know that you're the beneficiary of the account, or even better, the co-owner of that account, and the money automatically goes to you. Is your money without even having a will or going through the courts. That's huge. So, hey, you might don't want to do all your accounts, but let's say you want to leave some money to somebody, don't have enough money to pay a lawyer for a estate plan or will. Don't trust the online documents for a will. Simply add that person as a joint owner to your account, or if your bank does a beneficiary card, sign the beneficiary card. Saves you thousands of dollars. Saves that person that you want to give money to thousands of dollars and thousands of dollars at a time. Here's the big one. If you have a home, consult with a lawyer in your state. And like in Mississippi, there's some states that do a transfer on death deed. This will help prevent your property from becoming heirs property, which is a huge problem and a huge reason why people lose property. A lot of people try to get fancy and say, I want to put my property in trust. You put your property in trust, you deed the property to trust. You still got to have a trustee over that. And also, you still have to pay taxes. Sometimes trusts are not funded enough with funds to pay those taxes, and those properties still end up at the tax sale. So to save a lot of money without getting a will, without doing the trust, if you just have one house or two houses, simply do some transfer on death deeds for that property. That means the property belongs to you. When you pass away, you transition, then their property goes to that person that you have listed on the deed. Now, it may throw in a few bumps, meaning like, hey, if you decide to do something with your property, you may have to get that person who's they call it a remainderment. The person who's the remainderment, who's set to get that property, you might have to get them to sign off on it. So like, hey, I'm finna sell this house. I need you to sign off. That don't mean they own it, but they may have to sign off. It depends on what the closing attorney or closing agent will require. Some might say they might not have to sign off on it. It's up to that person and what the law requires in your state. But if you're not going to sell this house or try to get a loan on this house anytime soon, do a transfer on death deed. That would avoid having to get a will. That will also avoid having to go through the state. I still recommend getting a will if you do a transfer on death deed, but I'm not your lawyer. Consult with a lawyer in your state about that. But I tell my clients, hey, do a will and do the deed too, just for extra protection. But technically, if you're in a state that does transfer on death deeds, Mississippi just started like 2-3 years ago. That saves you lots of money, lots of time. If you pass away without deeding that property over to somebody, you transfer on via transfer of death deed, that means it goes to all your heirs. And you don't know your heirs gonna be happy. You don't know they're gonna fight. You don't know they're gonna have the money to pay an attorney to clear title, because once you pass away and that property's still your name, and because you haven't done a transfer on death deed or you haven't done a will, then that property is part of your estate, and they will have to open your estate and determine your heirs. It's different in every state than what happens in Mississippi. So get you a transfer on death deed that make that part of your estate plan if you can't afford an attorney to the property do you want. This is not legal advice. Consult in your state might not even have that. I know for a long time, Mississippi people would do a life estate deed with a remainderment, but this is just more clear transfer on death deed. So in Mississippi, definitely consult your attorney. Your other states, consult with attorney and see what they do there. But yes, those two things, a transfer on death deed and putting a beneficiary in your bank account will definitely help. Here's an extra tip. Consult with your lawyer, is not legal advice, but if you have life insurance, I don't recommend putting in your parents' name, because something happens to your parents before then something happened to you and you never got your beneficiary changed. Now the life insurance is part of your parents' estate. And so and that means that the life insurance is now the beneficiaries or the heirs of your parents are your siblings. So think twice for putting your mom on your life insurance. And also, if you get divorced, double check your life insurance. Think your ex-spouse might do the right thing when you pass away and give the money to your new spouse. That might not happen. I doubt it happens. So double check that stuff. Okay, that's enough of that. I hope you guys enjoyed those tips. I hope y'all learned something. Please subscribe to the channel. I'm trying to grow my channel. I don't have my law clothes on, but I am a lawyer. Been practicing law for 8 years. Thank you guys. Turn Dwayne Hobson. I'll see y'all in the next one.